Hi everyone, this is David McCree, CPA. Today I'm going to present a case study of an organization that had its exempt status revoked in error by the IRS. I hope you learn something from it. The purpose of this case study is to demonstrate a typical interaction with the IRS. This is a case where the IRS made an error which had serious implications for a tax-exempt organization. I was able to resolve the issue, but not without a lot of patience, persistence, and some knowledge of the law. This is a case where a tax-exempt organization's 501c3 public charity status was erroneously revoked under Section 6033J for failure to file a return on time for 3 consecutive years. The revocation date was January 15, 2014, as shown by the red arrow. The notice was actually received from the IRS dated June 16, 2014, but the notice was received by the organization on June 12th. A little information about the organization: it has a fiscal year ending August 31st, so that means that the 990 is due 4.5 months later, which would be January 15th. It could get an extension, 3-month extension to April 15th, and a second 3-month extension is available to July 15th. In this particular case, we're going to take a look at the 3 years of late filing which caused the revocation. First, 2009, the Form 990 was filed on time. That is not in dispute. The first late year was 2010. The organization admits that it filed that return late. Same thing with 2011. The organization admits that it was late. However, 2012, the organization did file within the extended due date of July 15th. So the 2012 Form 990 was due January 15th, 2014. The organization did request an automatic extension until April 15th, and then it later requested an additional extension to July 15th. And both of those extensions were received by the IRS and were granted. And there's paperwork to that effect. Now, the fact that the IRS revocation letter was dated June 16th shows that the IRS did not recognize the extended due date of July 15th. The organization filed the return on July 12th, about a month after receiving the revocation notice and well within the July 15th extended due date. The first phone contact with the IRS was on June 12th, 2014. The organization called the IRS, and the IRS phone representative told the organization that the approved extension requests were not valid, and in fact they were worthless. The IRS told the organization it would have to reapply for tax-exempt status and submit the user fee of $850. On July 8th, 2014, the organization contacted me for assistance. They were attempting to reapply for their tax-exempt status and to argue reasonable cause, and they just got confused about exactly what they had to do. So I reviewed all of their documentation, and I determined that their 501c3 status was actually revoked in error. So on the 15th, I sent a letter to the IRS explaining their error and requesting immediate reinstatement of 501c3 status. Along with the letter, I included the following supporting documentation. I included copies of the CP211A notices that the IRS had sent acknowledging that it received the extension requests and that it approved those extension requests through July 15th. I included a copy of certified mail postmark showing that the 2012 return was mailed on July 12th, 3 days before the extended deadline expired. And I also included a copy of a page from the IRS's own website which states that an extension on a third-year return is valid. Now, I had UPS tracking which showed that the IRS received my letter requesting reinstatement on July 18th, and I also received the return receipt from the certified mail, and that was stamped received on July 21st by the IRS. I followed up with a phone call on August 20th. I called exempt organization accounts, And the IRS phone representative said that there's no record of any correspondence having been received, despite the fact that they had marked my correspondence received. She tells me to wait 30 days and call again. Well, I couldn't quite wait 30 days, but on September 10th, I called again. The IRS phone representative once again says there's no record that any letter has been received and I need to wait another 30 days. I protested, and so she agreed to fill out Form 911 to request assistance from the taxpayer advocate. Now, for those who don't know, the taxpayer advocate is a supposedly independent service within the IRS which helps to expedite matters that aren't being resolved in an appropriate time frame. I was told that the taxpayer advocate would call me within 7 days, which in fact she did on September 16th. We spoke. The taxpayer advocate wanted copies of everything that I had already sent in because the left hand doesn't communicate with the right hand at the IRS. Now, the taxpayer advocate wasn't really familiar with exempt organizations or with the exempt organization division. However, she was interested in being helpful. We discussed the issues and I explained why the IRS was in error. She suggested that maybe there were some other reasons that the organization had been revoked. And I explained that the only reason in evidence for revocation was that the 6033J 3-year late filing rule was in play and that the IRS just needs to go ahead and reinstate, admit their mistake, and then if there's other issues with other returns, then we can deal with that later. She seemed to agree with that, and she said she would try to expedite the matter. So I immediately emailed copies of all the documents to her. She promised to follow up by October 6th, which she did. Follow up with me, that is. Unfortunately, she said there was a delay in receiving the documents that I emailed to her, and she'd been out sick for a week, so really nothing had been done yet. But she said she'd get right on it, and she promised to get back to me by October 29th. At this point, the client's thinking about calling their state legislator for help, but I'm encouraging them to just hold off on that a little longer. October 29th, the taxpayer advocate called me to follow up. She said that she still has not heard anything from exempt organization accounts, but they report that they will reply by November the 14th, and she'll follow up with me by November the 17th. Finally, on November the 10th, the organization contacted me and said, hey, we received a letter from the IRS admitting that they made an error, and they're telling us to just disregard the revocation notice that they had sent before. So finally, we got some success. But we really still don't know exactly why the error occurred. It's possible that the IRS was confused by the August 31st fiscal year end, and it could be that they posted the 2012 extension requests to the 2013 year. It's also possible that the IRS was just simply confused by the wording in Revenue Procedure 2011-44, which states that the revocation occurs on the due date of the third year return without regard to any extension of time for filing. That little clause there that little phrase has caused more confusion, and we'll get back to that in a minute. But why don't the IRS just admit they made a mistake? Why don't they just fix it? Why does it take so long? If you look at the Internal Revenue Manual, they tell their employees how to deal with a caller that states the organization should not have been revoked because it filed at least one of the 3 returns on time. They instruct their employees to remain non-committal when you're taking a referral on a potentially erroneous revocation, and do not tell the caller that it appears that the revocation is in error. So in other words, never admit you made a mistake. That's why you have to know the law, because the IRS clearly doesn't. I was successful in getting reinstatement because I knew the law and I was patient and I was persistent. So going back to why might the IRS be confused about whether a third year extension is valid? I think, as I said, that it comes from Revenue Procedure 2011-44, where it says exempt status is revoked on the due date of the third consecutive late return without regard to extensions. Folks, all that means is that if the third year return is not filed by the extended due date, the effective date of revocation is the original due date, not the extended due date. As long as the return is filed by the extended due date, there should not be a revocation. In January 2014, the IRS published Revenue Procedure 2014-11, which modified and superseded Revenue Procedure 2011-44. And in this new procedure, revenue procedure, the IRS has dropped the language that refers to without regard to any extension of time for filing. So that language is gone. This should have helped clear up the confusion, but apparently not everybody at the IRS got the memo. If you need help with formulating a reasonable cause argument with a letter to the IRS regarding revocation, regarding a late filing penalty, any other type of nonprofit penalty, you might be interested in my Form 990 Late Filing Penalty Abatement Manual. It's available on my website at form990help.com, ebook format or print format, and it addresses all of this stuff. Reasonable cause, how you make the argument, what the law says, what the IRS will accept. It does cover revocation and reinstatement. Thanks for watching. I hope this has been helpful. You can contact me at cpa@form990help.com if I can be of help to you, or if you have questions, comments, insights, or some wisdom on this topic. Just feel free to send me an email. This is David McCree, CPA at form990help.com.